Good afternoon. We are going to present a case, ASIC versus Rich, which is actually the requirement of our course, Business and Corporation Law, and it was really nice to do this as a group assignment and as a presentation as well. So let's see what this case is. Let's have a brief introduction of that. So Australian Securities and Investment Commissions had a case against Rich, which is the director or the former executive director of OneTel telecommunication company. So OneTel telecommunication company was really doing well at one point of time, and it had really huge investments and profits. So what went wrong and what later on become a failure to this company, OneTel. So we'll discuss some of the executive directors' roles and responsibilities, failure, and we'll discuss why, what went wrong or what was the reason behind the failure of this company. I asked Sabrina to give you some of the facts regarding the case. Over to
Facts
Sabrina.
regarding to this case is that OneTel was the telecommunication service provider company, and it was formed by the Jody Rich and Mark Silverman in Australia in 1995. The company was doing good and it expanded services in 1998 and 1999, where James Parker was the shareholder of the company who invested $600 million in the business. And in July 2001, the company was placed into the liquidations, and Parker and Mordach, PBL and New Corporation withdraws their return issues. Therefore, the company will collapse. And it was also found that the right issues are the main shareholders who give the main supports to the company. And in between, the Australian Securities and Investment Commission alleged that the director of the company breached the duty of care and diligence to the company. Therefore, ASIC sued the company for not performing the duty of care towards the company. Thank you.
Thank you, Sabrina. Over to Anita for the law applications.
Thank you, Sana. The law applicable in this case stated that the company is failing to properly access the OneTel financial position and inform the board of directors to OneTel true financial position and ensure the existence of system facilitating the flow of financial information to the board. As per the business judgment, the director of the company who formed the business must have at least the basic information about the business, and also the common law and in equity where the judgment is being made as per the good faith and material personal interest of the corporation law. And also, director have duty to protect the shareholder firms and the risk of the director giving harm towards the company. And the director also, in this case, have failed to act with due diligence and care, which the law required them to exercise in this case. So I think due to the failure of the due diligence and lack to perform their responsibility, there is a breach of the duty in director case. So for the breach of the duty, I think Desiree is going to describe furthermore.
Okay, every shareholders or investors in the company have the right to know about the financial facts about the company. In the breach of duties, the director breached the Section 181 of Corporation Act states that it is necessary that the director of other officer of the company must exercise their power and discharge their duties with due care and diligence that any reasonable person will exercise in those situations if they were a director or officer of the corporation or hold a position with the same responsibilities as the director or officer.
There's one thing, Desiree, I think audience might have this question, as we know, but audience might have this question, like why do you think the shareholders need to know about the financial decisions, or why the directors are liable to give them the required information?
Because they are investors in the company, and they have the right to know about the financial facts of the company.
Yes, that sounds right.
Yeah.
So let's have a look on the conclusion of this. So as per this case study, the court decision. I think everyone is now
like
thinking what's the court's
this is that, yeah.
decision. So the court actually dismissed the case. So yeah, when I read this article, I was like pretty sure that ASIC is going to win that.
Yeah, I'm also just know that ASIC will win the case. But can you please explain furthermore why this ASIC did not win the case?
Yes. See, Anita, I think court doesn't think what is right and wrong. Court works on evidences.
Yes, that's
If you provide much evidences to the court, you can give, you can, win the case against even a right person, even someone is right. But you have proper evidences against that person, so you can win that case.
Yeah.
So that was a lack with ASIC. ASIC was failed to provide the sound evidences or the good evidences to the court. So court has to decide on the basis of evidences, right? But the court, when ASIC gave the evidences in front of court, they were not required or they were not enough for the case decision. So at the end, the court just dismisses the case. But they have just done a bit of the expansion in the section 180 in 1. So they have done some of the expansions on that how the non-executive directors or the executive directors have their roles and responsibilities and how they have to, and why they are directors or they are the executives, because of course they have or they owe more responsibility towards the company. They must not use their personal interest think greater than the company's interest.
Yeah.
Must not do some decisions which are in favor of them or their like probably the one who they like.
Yeah.
That should be according to the company. You know what I mean?
Yeah.
So so there has been some expansion in the section 180, which was really good to decide the next coming cases if there are such kind of.
I think this is pretty much fair to ASIC as well.
Yes, yes, that's correct. Well, thank you very much to all. I hope so. This case will probably be a learning guide for you as well. It was really nice to do this assignment. Thank you very much.
Thank you very much.